Good evening, everyone. I hope I'm audible and visible. I am Anish, and I'm here on behalf of the National Law Training Institute. Today, we have among us Lipi Agarwal, who scored a very impressive rank of 34 in CLAT 2023. So, a lot of you requested for a legal reasoning masterclass to cover some basic concepts and also see the approach of toppers on how to approach the passages and how do they go about solving questions, what sequence do they follow, and what is their strategy to solve legal questions. So Lipi is one of the toppers of CLAT 23 and also scored a very impressive score in the legal section. So she'll be sharing her insights and also solving a few sample passages so that you can also get to know how to solve or how to go about a legal question. So I'll hand it over to Lipi now. We'll share a screen, and then yeah, if you have any questions, please feel free to drop them in the comment section, and we'll have a regular check on those. So yeah, handing over to Lipi. It would be great if you could introduce yourself before starting the session.
Thank you, Anish. Hi, everyone. I'm Lipi Agarwal, and I got a rank of 34 in the last CLAT 2023. And thank you for the introduction. Today, we'll approach the legal section. First, we'll do some basics, and then we'll see how you apply those basics to passages. So that is how you approach a legal section in general. So let's start.
Right. So just to be clear, we are doing contracts, right? Basics of contract law today.
Yes, basics of contracts.
Yeah. So if this session goes well, we'll have few more sessions covering everything like almost torts, constitution, crim law. If this session goes well and based on the feedback that we receive, we are planning to have a lot more master classes on CR, legal, English, GK, like basically every other CLAT subject. So yeah, feel free to reach out to us with any suggestion or feedback that you might have. I'll share the screen now. Yeah, cool,
So,
Lipi.
hello,
All
everyone.
yours.
Yes, let's start. So, what we need to do today is that we need to understand the legal reasoning section, how we go about the legal reasoning section when we already know the basics, and to apply those basics in a passage because legal reasoning passages are long. So, first, understand the legal reasoning approach. So there are generally 35 to 40 questions, and what you'll see in your mocks are generally 8 passages with 5 questions each. It can differ, it can vary, but generally there are 8 passages with 5 questions each, and these are of word limit 450 to 500, so they are kind of heavy to read. So the ideal time would be 40 to 45 minutes to solve the legal section. Now you are not expected to have this time in your first, second, or even like say fifth, sixth mock. Gradually and slowly you'll get there, but that should be your goal. Now how you fasten your reading speed in legal passages is to skim over it. You need to know what to read and what not to read, so that and now CLAT does not ask you for any legal knowledge, any prior legal knowledge whatsoever. You can just like not read anything in legal and go and give the paper. But if you do already know the concepts which are like torts, contracts, crimes, if you do already know them, so first thing you will be able to do it faster because you'll be like, ye to mujhe aata hai, I already know this, and just skim to the questions. And it will give you a certain confidence while you're solving your mocks and even the actual paper, that you can do it and you know already, you know the concepts already. So today we'll start with one such concept, the law of contracts. We will go through the introduction and the basics, nothing very confusing, just introduction and the basics. So for what the first of all, what is this fuss all about? What are contracts? So all of this is mentioned in the Indian Contract Act 1872. You do not have to read the bare act. It's all in simple English for you right now. So a contract is defined in Indian laws as an agreement which is enforceable by law. Here, there are two things that we need to unpack: an agreement and enforceable by law. Enforceable by law basically means that the law can force you to do it. You cannot escape it. You are bound to do it by law. And an agreement, well, you and I use the word agreement daily in our daily usages. It's nothing like that in contracts. The legal language states that agreement is any promise or a set of promises which form consideration for one another. So here also we need to unpack two things: first, promises, and second, consideration. Similar with agreements, these two words we use a lot in our daily usage, but different meaning in legal. So a set of promise or promises, which means in contracts, is a proposal when accepted. If I offer you something and you accept it, that's a promise. If I offer you, would you buy my car, and you say yes, that's a promise. Done. Very simple and clear. Now, if that promise has a consideration, it becomes an agreement. Now, what is a consideration? If I am selling you that car, I for say let's say I'm asking you for 5 lakhs in return. That is a consideration for me. You giving me 5 lakhs is a consideration for me in this promise, in this agreement. So promise plus consideration becomes agreement, and agreement plus enforceable by law becomes a contract. You can see it's really easy, but it confuses a lot of people. So promise is offer when accepted. An agreement is an offer which is accepted and has a consideration. A contract is an offer which accepted as a consideration and is also enforceable by law. That is a contract. The definition is broken up so you can understand it clearly. Now, what makes a contract a contract? What essentials do you need to fulfill for a contract to become a contract? Right? These are certain essentials: offering acceptance, certainty, lawful consideration, intention to create legal relation, lawful object, competent parties, free consent, and must not be expressly declared void. We'll skim through all of them, but first of all, let's do the important ones, which are offer and acceptance, lawful consideration, and certainty. So what is an offer? In general, simple terms, I offer you something, and I am hoping that you say yes. I am offering. Now, what am I offering you? It can be something positive or it can be something negative. I'm offering you that I will do something for you, or I'm offering you that I will not do something. I will abstain from doing something, and I am hoping that you say yes. That's basically a offer in Indian contract law. A proposal to do or not do something, and in the hopes that I obtain the assent of you. Now, offers can be express or implied. Express offers are in actual terms. I say it to you or I write it to you. It's clearly written or spoken, or it's clearly conveyed. I say that I'm selling the car to you. I'm offering you that you may buy a car from me. Offer. But if I do some actions that uh, convey that I'm offering you something, I do not say it, I do not write it, I'm conveying you through some other things, some other actions, that is an implied offer. Let's say I'm a coolie. I hope you're aware of the term coolie. Let's say I'm a coolie in a railway station, and I just pick up your luggage and pick up your luggage and look at you, and you are not saying anything, I'm not saying anything. That is an implied offer from my side to you, that may I pick up your luggage, and in return I am expecting that you will give me some money. Those words are not said anywhere, it's just through the actions that it is conveyed. That is an implied offer. Now, offer can be specific or general. Specific offer is to certain people, like specific people, and only those people can accept the offer. The car offer I made it to you, and only you can accept it. Your friend cannot come and say to me that you accepted it. You have to accept it. Right? That is a specific offer. Now it can be one person, two persons, three persons, any number, but they should be definite. General offers, on the other hand, general offers are made to like public at large. If and anyone can accept them. If I put up an advertisement saying whoever can bring me a dog in the next 2 hours gets 1,000 rupees from me, that is a general offer. Anyone can do it. I do not know that person, whoever that might be, and there is no specific person that has to accept the offer. Anyone who can bring me a dog accepts the offer. So that is a general offer. Now, communication of the offer, that's basic, simple sense that if I'm making an offer, I cannot just mumble it to myself, right? I have to convey it to you. I have to convey it to the person that I'm making the offer to. Or else, how would you know that I'm making an offer and I'm just daydreaming about making that offer, right? Non-conformity, no non-conformity term of acceptance. Do not get confused. Big words, I know, but non-conformity of acceptance is a term where you can say, for example, when I offered to give sell you my car, I say, if you do not answer me in the next 2 hours, if you do not answer me at all, I will understand, or I will assume that you have agreed to buy my car. I cannot do that. The law forbids me from doing that. That cannot be a valid contract if I do it, right? Two identical cross offers cannot be an offer. If I say, would you buy my car for 4 lakh? And you say, I propose to buy your car for 4 lakhs. Although it may sound like we are in agreement, but it is not a valid offer. You just counter offered me something which is identical, but you countered offered me. Now I have to accept it first. You cannot accept my first offer now. I have to accept your offer now, and that is a whole different offer now. The invitation to offer is not an offer. That this is a very good concept that you may have stumbled upon in mocks and all. Invitation to offer is basically, I invite you to give me an offer, then I will accept it. I am not making an offer. For example, if I am, let's say, an auction, I have to auction my, let's say this is an artifact, I'm auctioning it. Now I am waiting for you to offer me some price, and then if I accept it, we have a deal. But I am not making an offer right now. There is no offer from my side. I'm just saying, agar kisi ko, if anyone wants to buy this artifact, please tell me your price, and if I deem it fine, I will accept your offer. That is an invitation to offer and not an offer. So this was all offer, a proposal to do or to abstain from doing something so as to obtain the assent of the other person. Now we move on to the second important essential of contracts: acceptance. I made the offer, okay, and I made the offer to you. Give I may sell my car. I want to sell my car to you for 5 lakhs. And I go to the and you do not give me 5 lakhs, and I go to the court. She's not giving me 5 lakhs. They were supposed to give me 5 lakhs for my car. That is not something that can be enforceable against you, because you have not accepted my offer. So acceptance is when the assent is given by the offeree. New term, offeree. So offerer and offeree. When I make the offer, I am the offerer, and when the person that I'm making the offer to, is the offeree. Difference. So the proposal, whenever I made a proposal, I made an offer, you accepted, it becomes a promise. Now, an offer can be revoked before it is accepted. If I made the offer to sell my car, before you can say a word that says acceptance, before you can say that you accept my offer, I can revoke it. I can take my offer back. I'm not selling it to you now. I changed my mind. But after you have accepted it and conveyed it to me that you have accepted it, I cannot revoke my offer now. I'm legally bound by the offer now. Now, the offer must be so the acceptance must be absolute and unqualified. What does an absolute and an unqualified acceptance mean? Whatever I laid out to you, whatever offer I gave to you, with whatever terms, you have to accept it as it is. If I tell you I want to buy my car, sell my car to you for 5 lakhs, and you say, okay, I am ready to buy your car for 4 lakhs, that is not an acceptance. That is a counter offer. You are making another offer. That is negotiating and counter offer. Basically, that is not an acceptance. You need to say that you are buying my car in 5 lakhs. That's it. That is a valid acceptance. Otherwise, it's not. It must be communicated to the offer in the reasonable amount of time. Just like an offer, I have to communicate to you my offer in a reasonable amount of time. Same goes to you. You have to communicate your acceptance to me in a reasonable amount of time. You cannot wait for my car offer for, I don't know, 6 years to pass by to say, oh yes, I accept your offer. Now you're bound to sell me your car. No, I'm not. That's not a reasonable time to accept that offer. So the reasonable amount of time is subjective. It differs from business to business, trade to trade, contract to contract. That's different. Now, communication, a very interesting concept that we're going to study. Communication of acceptance is complete against the offer when it is put in the course of transmission, and against the acceptor when it reaches the offerer. For example, you are conveying your acceptance of that car to me through a letter that you have to post through a post office, a post box. So the time you post it in the post office or the post box is the time when the acceptance is completed against me. Now I am bound to this contract. I am bound to sell you my car, because you cannot revoke your acceptance now. There is no way you can get that letter back and revoke it. You have given it out, and it's going to the post office, and it's going to be reaching me. Now, when is the acceptance completed against you? The moment that I get that letter is in my hands and I have read it, that is the moment that acceptance is completed against you, right? And that the entire acceptance saga is complete when I read it. Now no more acceptance is needed. Now we move on to certainty and consideration. Certainty, very simple, very basic concept. The terms of the offer, whatever I'm offering to you, must be certain, definite, clear, must not have more than one interpretations, right? To it for it to be a valid contract. For example, I have five horses. I have five horses, each of different breeds and different colors, black, white, whatever color horses are, and I offer to you, I want to give you one of my horses for 5 lakhs. That is not a certain offer, because which horse? The black one, the white one? Is there a brown horse? The brown one? Which one? That is uncertain. So that would not be a valid. It would not create a valid contract. Now the last and most important one, consideration. Consideration is basically something in return or something. The Indian contracts, everything in contracts work on the basis of no one should benefit out of someone without giving them something in return. That is basically the concept, the motto. So something should be in return of something. I offered you my car, you will give me 5 lakhs in return. That is consideration. The something in return of something is consideration. Now, some facts about consideration. First, it is at the desire of the promiser and not any other person. My friend, if I am the promiser, I am promising. Promiser and promisee, new word alert. Promiser is basically when I make a promise, I am the promiser, and you, because I made the promise to you, you are a promisee. So a promiser, me, can only I can only give you the consideration at the desire of me. A third friend of mine cannot come in between and tell you that I desire to sell this. No, it should be on my desire, because I am making the promise. Now, the promisee can shift the desire to any other person. Your friend can come and give me that 5 lakhs if you have authorized it. Okay, it may be in the past, present, or future. Consideration can be past, present, and future. Past consideration is basically, for example, you have tilled my, not tilled, you have you have done some gardening work in my garden, plowed my garden, whatever that word is, gardening work in my garden, and that you did that 2 months ago and you did not expect to get paid. And today I'm like randomly, oh, you did nice work, I promise you that I will pay you 1,000 rupees tomorrow for that work that you did 2 months ago in my garden. That is a valid consideration. And I am legal, if you accept it and all other essentials are fulfilled, I am legally bound to give you that 1,000 rupees tomorrow. Present consideration, very simple, very easy. I give you my car, I give you my car keys, you give me the 5 lakh rupees. Present consideration, it happens simultaneously. Simultaneously, present consideration. Future consideration, I advance payments are basically future consideration. I give you the money and I give you 1,000 rupees today, and I'm like, 2 months after today, come to my garden and do the gardening work. That is a future consideration. I will receive it in the future. I will receive your gardening work in the future, not today, not in the past. Future consideration. It must be real, certain, and lawful. Real, certain, and lawful. Certain consideration, we have read about certainty अभी थोड़ी देर पहले. Real consideration, basically just what real means. And lawful consideration, I cannot expect you to be like, I me to be like, I give you 1,000 rupees and tomorrow kill this person for me. That is unlawful. It defies the purpose of law. It is basically unlawful to kill someone. So I cannot have that as a consideration. I have to have something lawful as a consideration. The consideration may be positive or negative. A positive consideration is me giving you something, me giving you some benefit, me giving you a payment in money, monetary terms, is a positive consideration. A negative consideration is me giving up some of my benefits, or me giving up some of my profits, or me giving up some of my legal rights. That is a negative consideration. If you have a profit, I'm giving you some of the profit, it's a negative, it's a positive consideration. If I give up some of my profit, that is a negative consideration. And lastly, consideration need not be adequate. Um, if both of the people agree, a car that is worth 4 lakhs rupees can be sold at a 10,000 rupees price. Now, in general sense, we see it is not adequate. Common sense laga ke it is not adequate to sell a car worth 4 lakh rupees and 10,000 rupees, right? But in legal terms, it is a lawful consider. It is a valid consideration, because consideration need not be adequate when if both of the parties agree to it, right? So this was all the basic, the most important essentials. Now we move on to the simple essentials. You will understand them very quickly. So we have done offer and acceptance, we have done certainty, we have done lawful consideration. Now intention to create legal relations, very easy. Intention to create legal relations is when you and I, when we have an agreement, we have a contract, both of our minds should have an intention that if you or if me do not play my part, do not do my part of the consideration or my part of the contract, we can drag the other person to court. So the court is involved, the law is involved. That is legal relations. In commercial relations like businesses and all, it is presumed that there is a legal relation. In domestic relations, on the other hand, generally it is presumed that they do not have a legal relation. If I tell my brother that if you score really well in the next test, I will buy you whatever, I will buy you chocolates for the next month. Now, clearly, the intention to create a legal relation is lacking here. You need to just apply the common sense, and you need to see that I do not desire that if he does not do his part of the promise, if he does not bring good grades, or if I do not give him the chocolates if he does, we cannot drag each other to the court. The intention is missing. However, the relationship, like father, mother, or whatever the family relations, they can create legal relations. It is presumed that they generally lack the intention, but they can. There is no rule that a father or a son or a sister or a brother cannot be in a contract. They can. The lawful object, the objective should be lawful. The objective of, if your objective is to hinder something legal, that, or your objective is something illegal, that is not a valid object, that is not a lawful object, and your contract cannot be said to be a contract. Competent parties, in general, the basic thing you need to remember here is competent parties, adults of sound mind. That's it. Adults of sound minds. Adults is basically 18 plus, anyone who is 18 plus, and sound mind is basically whoever is in position to understand the happenings around them, understanding what is happening, and understanding the terms of the contract is in a sound mind. And then free consent, it's a deep topic, we have to take another class for it, I guess. But free consent is basically whenever you consent, whenever you're accepting my offer. Let's say you're accepting my offer of that 5 lakh of the car in 5 lakh rupees. It should be your consent. No one is forcing you. It should be not due to any influence whatsoever. You should not presume under a mistake, whatever. It should be your free consent. You have understood what the terms of the contract are, and you freely consent to it. Only then it can be called a valid contract. If not, then it is not a valid contract. Then must not be expressly declared void. It's easy. Some contracts, like contracts which restrain someone from marrying, or contracts which restrain someone from carrying out a trade, a business, some of them are expressly declared ki these are not valid contracts, these cannot be valid contracts. And where are they declared? In the Indian Contract Acts. So it is valid, it is declared that some types of contracts cannot be valid contract whatsoever. So apart from those other contracts, if they follow all the other essentials, can be said valid. That's it. So we have done offer, acceptance, certainty, consideration, or other essentials. Now we shall apply these, and we will apply these two passages the same, and you will understand how having the prior legal knowledge of it makes it very easy for you to solve passages, right? Give me a second. So these are the passages that we'll be solving today. um, let's start with the first one. um, So now, what you need to understand before solving a passages, generally, when you see the first paragraph or even the first 3 to 4 lines, you can identify what the passage is about. And if you identify it and you are like, I know this one, so you can skim through it. You know that you will not take much time in it. If you don't know it, then you know that I have to read it fully. So that is how you manage your time in your head. That I have to give more time to this passage, or would it be easier for me to solve it in less time? So this, if we talk about this specifically, it's the entire process on contract. So it's about contract law that we have read in the first line. It's about a proposal. Okay, when persons signify a person willing to do something. So it's about offer. So we can clearly see that this definition is the definition of an offer, right? A person should not have only here are some essentials, and then there are essentials of an offer. We have already studied about it. We can do it fast. There must be two parties, of course, basic. One making an offer, one accepting the offer. Two parties are included. They can be legal persons as well artificial persons. Artificial persons are basically businesses, companies that are not persons in general sense, but they are artificial persons and can enter into contracts. Now they should be communicated. Of course, we that is the basic sense that we talked about earlier. It should be communicated. The communication is mandatory. Offer is valid if conveyed to the offeree. The communication will be expressed or implied. The communication can be expressed or implied. It can be communicated by terms such as mouth, message, etc. Skim through it. Section 4 of the Index says the communication process. Now, this is something you cannot skim. When you identify that there is a good concept that is coming in the next line, you are not skimming through it. You're reading it and you are marking. Underline it, circle it, whatever you want to do. Mark the important words that you think that may come as a question later on. Communication of a proposal is complete when it comes to the awareness of the person to whom it is made. So communication is complete when it comes to the awareness of the person. When I'm aware about the when I'm about the proposal. It must create legal relations. We talked about it. Legal relations. There should be an intention to create legal relation. Then invitation to offer. Market. Invitation to offer is not an offer. An invitation to offer, not an offer. We have already studied about it. Skim through it. It must be certain and definite. We have read about. We have studied about it. Certain and clear. It must not be ambiguous. We know it. Specific or general, एक इंसान के लिए हो सकता है, दो इंसान के लिए हो सकता है, specific people or public at large. We know it. So just skim through it. This person particular the general offer secured by any person. We already know it. Invitation to offer is not a type of offer per se. Now it is a contradicting something, so we need to be careful while reading it because it may be something that we have not studied. It is imperative to distinguish both to even construe what an actual offer is. Invitation offer is an offer to negotiate, an offer to receive offers, an offer to chauffeur. So it was not something important. Communication of offer. Now the communication. We're talking about communication here. Communication is complete. Underline it. Many questions can come on it. Communication of offer is complete when it comes to the knowledge of the person to whom it is made. Communication is complete when it comes to the knowledge of the person to whom it is made. If I make an offer, you need to be communicated to it. There should be a communication to you. Revocation of offer anytime before the communication is the proposal, but not afterwards. We have already studied it. As against the proposer is also a good concept that we need to underline or mark. Communication of acceptance, good concept coming. We have already studied about it though. The communication of acceptance complete as against put in the course of transmission. So course of transmission here means whenever you send it. So sending the postcard was course of you have sent it in the course of transmission. As the power of the acceptor against the acceptor comes the knowledge of the proposer. We have just studied this concept, so we know that we have to skim through it. When a letter of acceptance is posted, the proposer becomes bound, but the acceptor will be bound only when the letter is received by the proposer. We have just studied it. A complete contract arises. Now we have not studied it because it says something about the place of the letter of acceptance. We have not studied it, so we have to look through it closely. A complete contract arises on the date when the letter of acceptance is posted and the contract is deemed to have been made at the place where the letter of acceptance is posted. Basically means that if you posted the letter of acceptance, that is the date when the contract arises, and that is the place. If you posted the contract if you posted the letter of acceptance in Delhi, that is the place where the contract is made. The contract is deemed to have been made. Done with the passage. We have marked everything. Now we move on to the questions. We'll do the questions slowly. Sapna and Rahul were good friends. Nonsense line. We do not need to know it. Rohan came to meet Sapna at her house while having tea. Sapna said to Rohan, "I'm really looking for a buyer who would buy my house for 5 lakhs." Who said to who? Sapna said to Rohan. And what did she say? That she's looking for a buyer who would buy my house for 5 lakhs. एक दिन बाद, after a day, Rohan transferred 5 lakh to Sapna's account and demanded her to transfer the house to him. Sapna resisted, saying that there was no offer. Here, Sapna just said that I'm looking for someone that will offer me 5 lakhs for my house. So this all translates to an invitation to offer. Now, if Rohan brings the 5 lakh and drags Sapna to court to give him the house, he cannot. He will. There is no breach of contract because there is no contract, because one essential is not fulfilled. What it is it? What is it? Offer. The very essential. Sapna, let's come to the options. Sapna is correct because there cannot be any legal relationship between friends. Entirely incorrect option because there can be legal relationship between friends, and nothing about legal relationship not being between friends has been talked about in the passage. So even if you do not know about it, passage, nothing is said about it. Sapna is incorrect because all the essentials of offer are being fulfilled. They're not, because the offer is not there. There is no offer. There is only an invitation to offer. Sapna is correct because this offer cannot be. This offer doesn't fulfill the essential conditions. Seems correct to me. Now we shall see the last option. Sapna is incorrect because Rohan has already paid a 5 lakh and she needs to deliver. No. Even if Rohan has done his part of the contract, there is no contract. So there is no obligation for her to pay do her part of the contract. So the correct option here is C. Sapna is correct because this offer doesn't fulfill the essential conditions. And how did we get to it? By just one line that Sapna said, I am really looking for a buyer who would buy my house for 5 lakhs. I am not telling you, I'm not offering it to you, but I'm looking for a buyer who will offer me 5 lakhs in return of this house. That's it. So you need to also mark it in the questions. First, what you need to mark in the questions is who are the people involved, who is saying it to who, because that is very confusing when there are like larger questions. You get confused. Oh, who said it? Who said it? Who said it? That just becomes confusing, especially in contracts. So the persons involved, what do they offer, buy, sell, whatever that is. It is an offer question, it is a proposal question, it is an acceptance question, what it is, just that. Next question. Mayak and Upasna were in the same college. Mayak had bought a new laptop and was in search of the buyer for her old laptops or different brands. So here she had old laptops of different brands connected to something, some example that I gave a while ago of the horses. I had 5 horses of different breeds. When Upasna got to know about this, she offered to pay 30K for a laptop to Mehak, and she agreed to this. Now, what did she offer? She offered 30K, that is definite. But for a laptop. Which laptop? Which laptop? She clearly Mehak has a lot of old laptops and different brands. Even if they were of the same brand, we could be like, okay, give anyone, doesn't matter, right? But they're different brands. So, is this a valid offer? Let's go to the options first. Yes, it is a valid offer as all the essential conditions are being fulfilled. I don't think so. No, this is not a valid offer as it is not definite and certain. I think so. It is not definite. There are a lot of different brands, and she said, "Oh, laptop. Which laptop?" Yes, this is a valid offer as Upasna has offered to pay 30K and Mayak has agreed to it. Where did okay, has offered to pay 30K. Done. Mayak has agreed to it. Done. There is an offer and there is an acceptance. But where is the offer certain? There is not a valid offer. No, this is not a valid offer as there is no creation of legal relation between college students. Again, what we saw in the last question between friends, same thing. Between college students, who said? No one said that. There can be legal relations, and even if you do not know it already, the passage says nothing of that sort. So the correct option would be B, as it is not definite and certain. Now, one thing about this questions or about questions like this, even if you do not click, even if it does not click at the time that you're reading the question, if you go to the options and you see definite and certain, and you're like, well, is this offer definite and certain? And then you go to the question and you're like, maybe it is not definite and certain. Maybe B is the right option then. So you can also work backwards, although it takes time, but at least it will give you accuracy. When you practice it a lot, it will take lesser time. So you can also work backwards. 83. Parth had a business dealing in soap products on 20th August 2019. So Parth hai, there is a Parth, there is a soap business, soap products. Dates. Now this may look like a mathematical question, but trust me, it is in the legal section and you do not have to apply any mathematics. You just need to remember the facts stated in the passage. Now Sugandha on when 20th August, so 20th because everything is August, I guess. Sugandha made an offer to Parth through letter from Delhi. So Sugandha is the offerer and Parth is the offeree. She made the letter of offer from Delhi. to sell him 500 soap products. Now if he is dealing in business and she has asked for 500 soap products, it is a definite offer. It will not be an uncertain offer, it is a definite offer. And for rupees 200, this letter reached Parth. When is the offer reaching Parth, reaching the offeree? Communication of offer is completed 21st August, because the communication of offer is completed when I made a promise and it reaches to you. Sorry, I made an offer and it reaches to you. So whenever it reached you is when the the offer was complete. The communication of offer was complete. So 21st August is when the communication of offer is complete. Now, Parth replied to the letter accepting the offer on 24th August 2019. So Parth gave his acceptance. The letter of acceptance is posted on 24th August 2019 and from Mumbai. It reached Sugandha on 25th August in Hyderabad. So 24th, 25th. Question is communication of offer. When the communication of offer complete hua hai, and when Sugandha had a chance to revoke the offer. So it is a question which involves a lot of principles together. So communication of offer was completed. Just remember, communication of offer was completed. If you do not remember, communication of offer completed when it comes to the knowledge of the person to whom it is made. So who made the offer to who? Parth made the Sugandha made the offer to Parth. So whenever it reaches Parth is when the communication of offer is complete. So 21st August. So we can just eliminate the options that do not have 21st August in them. So C cannot be the answer and A cannot be the answer. Now the war is between B and D. Now the second part of the question is when Sugandha had a chance to revoke the offer. Now when can you revoke the offer? If you remember, you can revoke the offer before it is completed, before the acceptance is completed against the proposer. So, and when it is completed against the proposer, when it DMD proposer, letter of acceptance posted, the proposer become bound. The letter of acceptance is posted. Whenever the letter of acceptance is posted, the proposer is bound. So what does it mean? It means that whenever the letter of acceptance is posted, that is when the acceptance is complete against the proposer. The proposer here is Sugandha. So whenever she where did the passage go? Yeah, right. The proposer here is Sugandha, right? And whenever whenever the letter of acceptance is posted by the other person who was Parth, that is where or when the that is when Sugandha had a chance to revoke. So before 24th August, he posted the acceptance on 24th August. So before 24th August, B option. Took a lot of time, but at least do it right. Now, with reference to the facts mentioned in question 83, when can the contract said to be has arisen and at which place? So when was the contract arisen and where? If you remember, that was in the last part of our passage. The complete contract arises on the day when the letter of acceptance is posted. It does not have to reach the other person when the letter of acceptance is posted, and it is deemed to have been made at the place from where the letter of acceptance is posted. So it all depends on the person that posts the letter of acceptance. And who posted the letter of acceptance? Parth did. Letter accepting the offer on 24th August from Mumbai. So 24th August and Mumbai would be the correct option. I guess it's B. It's B. Which of the following is incorrect as per the passage? It is an RC type of question which you do not find a lot, but you can still have them less frequently, but you can have them. So, an invitation to offer is an offer to negotiate, an offer to receive offers. It is correct. There is nothing wrong in it. Invitation to offer is an offer to negotiate, offer to receive offers. And if you are still skeptical, I guess it should be in the passage. Invitation to offer era. Invitation to offer to negotiate, and offer to receive offers, and offer to sharing, same thing. So an offer is valid if it is conveyed to the offeree. communication of the offer, that concept. Uh, when a letter of acceptance is posted, the acceptor becomes bound. Does the acceptor become bound? If Parth posted the letter, did he become bound or did Sugandha become bound? Sugandha became bound. So that is wrong. The acceptor and the proposer word here have been interchanged. The proposer becomes bound. The terms of the offer must be certain and clear. Really easy concept. And even if you cannot figure out the C option, you can do it by the process of elimination. If you go to A, it is clearly in, like as it is in the passage. B should also be as it is in the passage, and D is also as it is in the passage. C, if you go to C, a complete the letter of acceptance posted, the proposer become bound. The communication of acceptance is complete as against the proposer when it is put in the course of transmission. And it becomes when the letter is posted, the acceptor. That you can see clearly that the words have been interchanged, so it is incorrect. Simple question, simple. You do not even have to apply anything to it. So this is how you do a passage when you already know the essentials, and even if you know the uh, topic by large, there may be some one or two concepts in that, little concepts that you may not be familiar with. So you need to see what to skim and what not to skip. Consideration. Clearly the passage is about consideration because it is like consideration blah 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 blah, so it is about consideration. Consideration in contract law is an inducement given to the contract that is sufficient and promise. It is an inducement. I am inducing you. I am giving you something, some reason to enter into the contract. That is sufficient. It should be sufficient to render the promise enforceable in the court. The technical requirement, it's talking about something essential, something required, so we need to uh, read it properly. We cannot skim through it right now. Either a detriment incurred by the person making the promise or a benefit received by the person. We've already studied about it. We have studied how it can be positive or negative. Same thing applies here. It can be either a detriment, either a loss that I incur, or a benefit that I give to you. Thus, the person seeking must have paid, bound himself to pay. So these are the ways in which someone can make a consideration. Not exclusive, not exhaustive list, but some ways that can be used to make consideration. Already paid, bound himself to pay in money, goods, labor, or forgone some profit or legal right. In a contract, for sale of goods, for example, अगर sale of goods की बात करें अपन, तो the money is the consideration for the vendor. The money that I pay to buy something is the consideration for that person who is selling the things, and the property sold is the consideration for the purchaser. And what the property I get in return, the what are the goods that I get in return is my consideration. Now, this definition, however, leaves an answer question of what is sufficient consideration. Now, it tells you, the passage itself tells you that there is nothing mentioned in the definition itself, or in the contract law. You can say what is sufficient consideration, because that is a very subjective word, right? Up, you need to do you because this is a new concept. We have not studied about it. We need to read it fast, but read it. During certain periods of history, nominal consideration is sufficient. So nominal consideration was held to be sufficient. Sometime kisi zamane mein there was like, only give me 1 rupee for this big car and you can have it. That is sufficient. Even a cent or a peppercorn. Gradually, the courts came to require that consideration be valuable. It has to be something of value. It does not have to be equal in value for what is received. You do not have to pay exact 5 lakhs for a car that is valued at 5 lakhs. We can negotiate it to something less or something very less too, but it should be something of value. The money should have something value, or whatever you're giving it through, whatever the consideration, it should be something valuable. The courts have had to decide specifically whether act of forbearance. So this is like, this just says that the court do it. The court do it. The court decide whatever it is. Over the passage of time, the definition, the interpretation by courts also change. Giving counter, these are the ways. We do not have to read it. The doctrine that a consideration is necessary for contract is to be enforceable has a number of functions in the contract law. So why is the consideration is necessary such a big deal? Why? Because it provides evidence that a contract exists. It has a cautionary function कि कोई अपना promise तोड़ के नहीं जाएगा. Deterrent function, questionability. These are all something that we do not have to read in detail or even understand in detail. Questions. Question number 102. Which of the following will not be a valid contract due to lack of consideration? So we have to tell ki which of the following does not have a consideration. X wishes to sell his television set to Y in exchange for some stones that he found in his backyard. So television set, some stones that he found in his backyard. Is it? Wait. Yes, X promises to marry Y's sister in exchange for a beat up BMW car. It is good. Now, sorry, we were on first option. Television set, stones. There is some consideration. I guess we can say that there is some consideration. It is not at par of it, but it is some consideration. X promises to marry Y sister in exchange for BMW car. There is consideration. एक बोल रहा है कि मेरे को marry करना है, एक बोल रहा है कि तुमको उसके बदले BMW car मिल जाएगी. There is some consideration. X promises to give Y all the tender coconut tree if Y agrees to climb the tree. Okay. Y is getting to the tree and Y is getting all the coconuts himself. What is X getting? What is X getting? Nothing. Nothing. X is getting nothing here. So the correct option would be C. Assertion reason. Again, these kind of questions do not frequently come in your mocks if you've seen, but they may come. Assertion lack of consideration makes an agreement unenforceable. So that is true because that was clearly mentioned in the passage that consideration is an important essential. Consideration proves that a contract exists. That was also clearly mentioned in the passage when we talked about the functions contracts. It is proven that evidence that the contract exists, right? So consideration proves that a contract exists. Okay, uh, these two are correct here. These two statements are correct. But now we also have to see if reason is the correct explanation for the assertion. If lack of consideration is makes an agreement unenforceable because a consideration proves that a contract exists, it does not sound like a reason. They are both true, but this is not the reason for the assertion. Okay. 104. X is an underworld don and has many enemies. Okay. X hires Y as a hitman to kill one of his enemies, Z. So X and Y के बीच में there is a contract. There may be a contract. Let's see. In return for this, X promises to give Y $500,000. So Y is giving something to X. Y is giving a murdered dead body to X, and X is giving to Y $500,000. Now, by the looks of it, it looks that it is all very illegal, which it is. But did the passage at all talk about illegal something? Did it? No. So we will assume that this is a valid consideration from both the sides. A valid contract has been formed because there is no consideration given a kind of an activity. Seems correct to me. Let's see other options first. A valid contract has been formed because X is an underworld don. What is this option, right? This is just plain wrong. Because he's an underworld don, he can make a valid contract whatsoever. No, the reason is not correct. A valid contract has not been formed because the mentioned activity is illegal, which renders the contract invalid. Now, in our general sense, in our common sense, we will be lured by the option C because it is illegal. And when you read the basics, we just study that the object cannot be illegal, the consideration has to be lawful. But was there anything like that mentioned in the passage? No. So, option C cannot be correct either. A valid contract has not been formed because X is not receiving any consideration for the same. That is just plain wrong. That is against the factual facts given in the question, because X is receiving something and Y is receiving something. So the correct option would be A. Last, 105. Which of the following can be inferred from the statement? Gradually, the courts came to require that the consideration be valuable, although not necessarily equal in value to what is received. And this is also an RC type question, but you do RC type questions for other passages, other sections too, so you can do it. The courts, so the statement, and we have to tell an inference, and there is a statement that the courts came to require that the consideration be valuable. We read about how pehle ke time pe they were like ki any nominal consideration is okay, but then they came to decide ki nahi, you have to give something valuable, which may not be equal in value to what is received, right? Let's skim through the options. The courts prefer to let the parties to the contract decide the value of the consideration exchange, which seems true, because think about it. If the courts came to require that the consideration be valuable honi chahiye. Ab ye valuable kya hai? What the value of this valuable is, you guys decide. But it should be something valuable. That is an inference here, I think. Let's skim through other options first. At certain points in history, it was deemed that nominal consideration was satisfactory. Well, this statement does not give anything about what happened in history, what happened afterwards, nothing. And it is also something that is clearly mentioned in the passage, which was related. This is a related statement, but it is not an inference. We cannot infer it for sure that at certain point in history or nominal. There may be something like certain points in history, only the equal amount was considered to be a valid consideration. Courts have had C option. Courts have had to determine whether acts of forbearance based on a promise are adequate in particular cases. Well, what it does not say anything about the acts of courts having to decide the acts of forbearance. Nothing. The line in the question says nothing about it, so it cannot be an inference. This is a cross. I am hoping to make a cross. The principle that a contract requires consideration to be enforceable serves various purposes within the law of contracts. Well, it does. That is true. It is a true statement. These three statements were true. BCD. But are they inferences? No. Option A would be the inference that is closest to being an inference from the uh, statements. So that would be it for today. That is how you solve the questions, and that was all from my side. Now, things that you need to take away from this whole class, whatever was, how to do the basics and how to apply the basics to the passages and skim over it. That's it.
Hi, Lipi. Thank you for that session. I hope it was very useful and enlightening for everyone who watched it live. Thank you, Lipi. Do you have any last piece of advice to ace the legal reasoning section for all the aspirants out here?
Well, one advice would be to keep reading recent laws, because if you keep reading them, you know what to study, what to read, and what not. That is just keep reading them. Do not rely on mocks or the coaching to give you the passages, serve them to you in a plate. Uh, Go on some websites, use the internet, and keep reading them. That would be one of the best advices right now.
Right. One question that most of the aspirants are faced with is whether they should solely rely on a core legal knowledge like contracts, torts, consti, or they should also rely on current legal knowledge like from live law, from bar and bench, from legal issues that are currently being talked about in the Supreme Court. So, what was your focus primarily on?
For them, what I would say is just take up the last CLAT, the CLAT that we gave, and see if there was any question from the static legal. No, all the questions, almost all I guess, were from the recent legal. It will help you if you study the concepts like law of torts and law of contracts. Of course it helps, but focus, I guess, like 60-40 ratio. 60 focus should be on the recent legal. Keep reading them from websites that I stated, live law, bar and bench, and a lot of websites that you are comfortable with, and just focus more on them and start understanding the judgments, because there is always one paragraph in those that is the most important one, and has all that is, and all that has to be said from the entire passage is essentially in that one paragraph, so you can save your time.
Right. Thank you for that answer. I think it would really help all the aspirants who are clueless about how to go about legal section preparation. So thank you, Lipi, and thank you everyone for joining in. We'll bring more such sessions on various other subjects and topics as well. Thank you so much for joining. I hope it was useful
Thank
for
you.
everyone. Thank you, Lipi. You can leave the session now. Thank you. Right. Is there any question regarding what NLTI is, what work we do, how do you enroll in the plan? If yes, I'm here for next 30 seconds. If you're not, if you do not have any question, I'll leave the session also. Right. I don't think there's any question. So thank you so much for joining in. I hope it was a productive section, a session for everyone. Thank you so much.